Welcome to CCPA Compliance Training with TrueVault. In this training, we'll tackle 10 key concepts and requirements under the CCPA. What is the CCPA? The consumer rights created by the CCPA, a business's disclosure obligations regarding information collection, its disclosure obligations regarding information sharing, how to handle a request to know, how to handle a request to delete, how to handle a request to opt out, requests from authorized agents, record-keeping obligations and government enforcement, and the importance of updating your information map. At the end, we'll ask you to take a brief quiz to test your knowledge. Let's get started. The California Consumer Privacy Act, or CCPA, is a privacy law enacted by the California Legislature in 2018. It became effective on January 1, 2020, and enforcement started in August of 2020. The CCPA grants rights to California residents, called consumers under the law, over the collection, sharing, and sale of their personal information by businesses. A business subject to the CCPA is any organization that collects personal information of consumers for its own purposes, such as providing goods or services to consumers, and that meets one of three criteria: has annual revenue greater than $25 million, or annually buys, sells, or uses for a commercial purpose, such as advertising, the personal information of 50,000 or more consumers, households, or devices, or derives at least 50% of its annual revenue from selling consumer personal information. Next, we'll learn about consumer rights. The CCPA grants consumers 4 new rights over their personal information collected by businesses: the right to know, the right to delete, the right to opt out, and the right to non-discrimination. The right to know is a consumer's right to know what kind of information a business collects and shares about them. Under the CCPA, a consumer can make 2 types of requests to know. First, a request to know general information, known as a request for categories, and second, a request to know their actual data collected by a business, called a request for specific information. A request to know categories is a consumer request to know the categories of personal information the business has collected about the consumer in the past 12 months, the categories of sources from which the business collects personal information, the business or commercial purpose for collecting it, and the categories of third parties with whom the business shares each category of personal information that it collects. A request to know specific information is a consumer request to know the actual information a business has collected about a consumer, such as the consumer's name, email address, and telephone number. The right to delete is a consumer's right to request that a business delete any information about the consumer that the consumer has provided to the business. When a consumer makes a request to delete, it asks the business to permanently delete that information. A request to delete does not apply to any personal information that a business has collected from sources other than the consumer, such as a data broker. The right to opt out is a consumer's right to opt out of a business's sale of their personal information to a third party. The CCPA defines sale broadly to include transferring or making available any personal information of consumers in exchange for money or anything else of value, like a service or even the promotion of one's business. The CCPA is not entirely clear on what constitutes a sale of personal information. However, it is commonly understood that behavioral, interest-based advertising may be considered a sale of personal information by the advertiser. That is because ad networks providing this service often build profiles on consumers and use information they gain from one source to provide services to other businesses. A business that sells personal information is required to give consumers the ability to opt out through a Do Not Sell My Personal Information link available on the business's homepage and through its online privacy policy. By clicking the Do Not Sell My Personal Information link, the consumer is making a request to opt out. The CCPA prohibits businesses from discriminating against consumers for exercising their CCPA rights. That means a business cannot deny goods or services, charge a different price or rate for goods or services, including through the use of discounts or penalties, or provide a different level or quality of goods or services to any consumer for exercising their CCPA rights. Now let's learn about a business's disclosure obligations regarding its personal information collection practices. Let's dive deeper into what a business is required to disclose in response to a consumer's request to know. A business must disclose 3 types of information concerning their personal information collection practices: categories of personal information collected, categories of sources, and business or commercial purposes for collecting information. Let's start by understanding categories of personal information before moving on to sources and purposes. Personal information means any information that identifies, describes, or relates to a consumer or a household. It also includes any information that can be used to identify a device, such as a computer, tablet, or smartphone. Basically, anything that can connect to the internet. Personal information includes common identifiers like name, email address, postal address, and telephone number. It also includes government identifiers like social security number, passport number, and driver's license number. Online identifiers would also be considered personal information, such as IP address, internet cookies, and other tracking devices. Personal information includes financial information like a person's bank account number, credit, or debit card number. It also includes medical information like prescriptions and health conditions. And it includes biometric information like fingerprints and geolocation information, such as a consumer or device's precise geographic location. Personal information includes a consumer's purchases and purchasing tendencies, such as products a consumer considered but did not purchase. This type of information is considered commercial information under the CCPA. Personal information also covers physical, visual, and audio information, such as photographs and voice recordings. Personal information includes professional information, like employment history and professional affiliations. It includes non-public education information, like school transcripts. And it includes employment-related information, such as information needed to hire an employee or administer benefits. For example, health insurance information and emergency contact information. Personal information also includes protected classifications under California or federal law. For example, race, sex, religion, national origin, disability, age, political affiliation, and others. Finally, personal information includes inferences, which are assumptions or data that can be derived from any other type of personal information, such as inferences about a consumer's preferences, behavior, and intelligence. Information is not considered personal information under the CCPA if it is de-identified. Information is de-identified when it cannot reasonably be associated with a particular consumer. The CCPA also requires businesses to have certain safeguards in place to prevent the re-identification of the information. Or when it is aggregated. Aggregated consumer information is information that it relates to a group of consumers and from which individually identifiable information has been removed. Or when it is publicly available. Publicly available information is information lawfully made available from government records. It does not apply to all information that can be found from any public source. Now let's move on to categories of sources. Businesses are required to disclose their categories of sources to consumers making a request to know. Categories of sources are the types of persons or entities from which a business collects personal information. Here's a non-exhaustive list of categories of sources: the consumer directly, data brokers, ad networks, internet service providers, data analytics providers, government entities, operating systems or platforms, and social networks. A business is required to disclose the business purpose for which it collects personal information. A business purpose describes a business's use of personal information for its operational purposes. Here is a list of business purposes in the CCPA: providing goods or services, security, sales and marketing, technical maintenance, internal research, short-term transient use, verifying or maintaining quality or safety of a product or service, and employment-related purposes. A commercial purpose describes the use of personal information to advance commercial or economic interests. An example would be using a consumer's personal information to advertise a product to them. A business is required to disclose when it collects personal information for a commercial purpose. Now let's learn about a business's disclosure obligations regarding its personal information sharing practices. A business is required to disclose the categories of third parties with whom it shares personal information. Third parties include any person or entity other than the business, the consumer, and the business's service providers. A service provider under the CCPA is an organization, like a vendor, who is contractually obligated not to use the personal information a business shares with it for any purpose other than providing the specified service. Here are some examples of categories of third parties: data broker, ad network, payment processor, data analytics provider, social network, and government entity. Next, we'll walk through the steps for handling a request to know. A business must acknowledge a request to know within 10 business days and provide information about how the business will process the request. It must respond in full to a request to know within 45 calendar days. However, It may extend the response period to a total of 90 calendar days from the date of the request if it has a reason to do so and informs the consumer of the reason within 45 days of the request. The CCPA requires businesses to verify a consumer request before processing it. Basic verification for request to know categories may consist of verifying two pieces of personal information the business has already collected about the consumer, such as name and email address. A higher level of verification is required for a request to know specific information. An additional third piece of information must also be verified. A business must obtain a declaration under penalty of perjury from the consumer, declaring that the consumer is the person who is the subject of the request before responding to a request to know specific information. When a consumer makes a request to know categories, a business must provide the categories of personal information it has collected about the consumer, the categories of sources, the business or commercial purposes for collection, and the categories of third parties with whom each category of personal information is shared. When a consumer makes a request to know specific information, a business must provide the specific pieces of information it has collected about a consumer. However, in responding to a request to know specific information, a business must not disclose sensitive information, such as Social Security number, driver's license number, financial account number, health insurance or medical ID number, passwords or security questions and answers, or unique biometric information. Now we'll walk through the steps for handling a request to delete. A business must acknowledge a request to delete within 10 business days and provide information about how it will process the request. It must respond in full to a request to delete within 45 calendar days. A business may extend the response period to a total of 90 calendar days from the date of the request if it has reason to do so and informs the consumer of the reason within 45 days of the request. As with the request to know, CCPA requires verification before processing a request to delete. Basic verification for request to delete may consist of verifying two pieces of information the business has already collected about the consumer, such as name and email address. A higher level of verification is required for a request to delete unique information, such as family photos or legal documents. In that case, a third piece of information must be verified against the business's records. A business is not required to delete any personal information that is not considered personal information. In other words, aggregated or de-identified information. Also, to the extent information is not easily accessible, for example, because it is stored on backup or archive systems, a business can delay deleting that information until the records holding it are restored and accessible. For accessible information, recall that a request to delete applies only to personal information a business obtains directly from the requesting consumer, not from other sources. Such personal information may be deleted by permanently and completely erasing it, except for data on backup or archive systems, de-identifying it, or aggregating it. The CCPA provides a robust list of exceptions to deletion that allow a business to retain and not delete personal information in response to a consumer request. The list of exceptions ranges from the need to provide goods and services and using the personal information for security reasons to complying with a legal obligation or for any purely internal use that is lawful and compatible with the purpose for which the consumer provided the information. Next, we'll turn to the steps for handling a request to opt out. A business must respond to a request to opt out as soon as it can, but no later than 15 business days after the date of the request. A request to opt out does not require verification. However, if a business has a documented reason to believe that a request is fraudulent, it can deny the request. A business must confirm to a consumer that it has opted the consumer out of any selling of information. A business is required to respect a consumer's decision to opt out for at least a year before requesting that the consumer authorize the sale of their personal information. A consumer's choice to opt in after opting out should follow a two-step process where the consumer makes and then affirms their choice to opt in. A business must obtain opt-in consent before selling the personal information of any consumer who the business knows is under 16 years old. In contrast, adults are opted in by default and provided a right to opt out. Next, we'll learn about requests from authorized agents. A business is required to allow consumers to submit CCPA requests through an authorized agent. An authorized agent is a person or entity that a consumer has given written permission to act on their behalf. A business may, but is not required to, verify the identity of the consumer who is the subject of the request and verify that the consumer gave the authorized agent permission to act for them. A similar concept is that a business may receive CCPA requests from an authorized agent who has power of attorney. In that case, a business cannot require verification of the consumer, but it can require proof of a person's power of attorney status. Now we'll take a closer look at a business's record-keeping obligations and how the government enforces the CCPA. Businesses are required to maintain records of CCPA requests, including requests to know, requests to delete, and requests to opt out, and the business's responses to those requests. They must maintain copies of these records for at least 24 months. Records must include the date and nature of the request and the business's response, including the basis for denying any requests. Businesses may not share these records except as necessary to comply with a legal obligation. The California Office of the Attorney General, or the OAG, enforces the CCPA. If the OAG becomes aware of a violation, it will give the business a 30-day cure period. For uncured violations, the OAG could assess civil penalties up to $2,500 per violation or $7,500 per intentional violation. Finally, we'll learn about the importance of updating your information map. The accuracy of a business's responses to consumer CCPA requests depends on its commitment to keeping its information map updated to reflect current personal information collection and sharing practices. An information map is simply a depiction of the flow of information into and out of an organization. Businesses should follow a few important steps to keep information maps up to date. When a business stops using a vendor, it should remove that vendor from its information map 12 months after discontinuing service of the vendor. When a business starts using a vendor, add that vendor to the information map if the business shares personal information with it. Review vendor privacy policies and terms of service at least annually for any changes and whether those changes trigger a change in the classification of the vendor. For example, is the vendor a third party or a service provider? And update the information map as needed. Congratulations on finishing TrueVault's CCPA compliance training. Your organization will send you a link to a short quiz to test your CCPA knowledge. If you have any questions, please send them to ask@truevault.com. If you would like to read more about the CCPA, please visit TrueVault's CCPA Learning Center at www.truevault.com/learn/CCPA. Thanks for your participation.